Hello everybody and welcome to our August webinar on shareholders agreements. Today Kate Chalker from our Sydney office is going to tell us all of the key points that should be included in shareholders agreements, as well as run through some of the issues that can arise and some of the things that we've seen in practice and in the cases relating to shareholders agreements. So before Kate jumps into the presentation, just a little bit of housekeeping for those that may not have used our webinar software before. Over on the right-hand side of your screen, you should see both the Files button and a Chat button. If you click on the Files button, that will allow you to download the PowerPoint presentation from today in a PDF format if you want to keep it for later reference. And if you click on the Chat button, that'll allow you to ask a question if you've got any questions during the presentation. There'll also be time at the end of the presentation for questions if you have them. If you type those into the chat box, I'll be moderating or reviewing those questions in the background, and at an appropriate time I'll jump in and ask Kate. So I'd like to pass over to Kate Chalker. For those that don't know Kate, she is an associate here in the Sydney office and has been with the firm for quite some time and practices across pretty much all of our areas, luckily for Kate, including doing lots and lots of shareholders agreements. So over to you, Kate.
Perfect. Thanks, Adrian, and good morning, everyone. Thanks for joining us today. As Adrian mentioned, today we'll be looking at shareholders agreements and particularly why they're so vital to have in place for companies, whether they're newly formed or whether they've been in existence for 20-something years. They really are a vital part of ensuring the future conduct and management of the company and making sure that the rights of shareholders are protected. We always say that when you go into business, when you start up a new company, you never do so with an intention to fail or with an intention to get into a dispute with your fellow business owner. But the harsh reality is that disputes do often arise, whether that's because of something to do with money or due to a power imbalance. But these disputes do arise in practice, so it's important to make sure that these types of situations are regulated and documented in the form of a shareholders agreement. So just in terms of an agenda for this morning's presentation, first I'll go through some of the common types of shareholder disputes, which we often see arise in practice. Then we'll look at the different sources of rights that shareholders can have, whether that is under a shareholders agreement or if the client doesn't have one in place, what are their rights under both the company constitution and also the Corporations Act. And we'll look at one of the main areas of recourse under the Act, which is the oppressive conduct regime. We'll go through a recent case as well that went to the New South Wales Supreme Court, which involved those oppressive conduct provisions, and we'll look at why that ultimately fell over for the applicant in that case. And then finally, with all of that in mind, we'll look at if we are putting in place a shareholders agreement for a company, what should they include? What are the main provisions that we need to make sure are covered? So as I mentioned, the first area that we will touch on is the most common source of shareholder disputes. So more often than not, these are the types of things where there leads to a dispute between shareholders. The first one that we often see is where you have a management deadlock. So for example, if you have two directors, if you have two equal shareholders, and you can't pass an important resolution without the agreement of both, what do you do in that situation, particularly where you don't have a casting vote and the relationship between the two parties has broken down? How do you make sure that you can make decisions to keep the company operating and keep the company moving forward? That's often a large cause for disputes between parties. Another cause for disputes is in relation to dividends. So when the shareholders think that a dividend should be declared, but the directors disagree and want to retain that money within the company. So in the absence of some sort of dividend policy or some other provision in the shareholders agreement, a dispute can arise as to whether a dividend should be declared, and if so, how much. And further to that money point, there can also be disputes arising because of money being paid to directors, not in the form of a dividend. So, for example, if they are employed by the company and they're receiving a salary, perhaps higher than what the market value salary for that role would be, or if they're receiving directors' fees, the shareholders, quite rightly often, might get upset about that money being paid to the directors and not instead being declared as a dividend to the shareholders. We often see disputes arise where we have what we call an uncooperative partner. I'm obviously not speaking about a partnership. I'm just referring to a director or an employee manager who's involved within the business. And for whatever reason, they just stop fulfilling their normal roles within the business. They might stop turning up for meetings. They might stop attending the business premises at all. Maybe you just can't get a hold of them. And that can really put the company into a sticky situation, especially if they are a director, if they are a majority shareholder. It might mean that you simply can't make any decisions on behalf of the company if you do have this person who's gone AWOL and has stopped participating in the management of the business. Another common source of disputes between shareholders is where you have an oppressive majority owner, or you might have a group of owners who together control the majority of the shares in the company, who are all working together. And that owner or that group of owners could recognize that they're in control, they have all the power when it comes to voting rights, and so they can try and force their views and their decisions on the minority shareholders, which might actually work to their detriment. So in our experience, these are the types of scenarios that can arise, which would likely lead to a dispute between shareholders. So in these types of situations, the question which we always get first is, what can I do about it? What are my rights as a shareholder? And to answer that question, we need to look at a few different documents. We need to see what is in existence and what rights they provide for. So the first question we would be asking is there a shareholders agreement in place? Because if the company and the shareholders have entered into that agreement, that will more likely than not take precedence over the company constitution or the corporations law. So it will be that document which dictates how the situation is to be dealt with. But if the company hasn't entered into that type of document, then we would need to look at the company constitution and also the Corporations Act. So the company constitution, it's a fairly basic document. I'm sure when you set up a new shelf company, it's included in the company register. Not sure whether any of you have actually been through the company constitution and seen the different provisions in there, but it is fairly basic. I'll go through, I think it's on the next slide, the things that are not covered within the constitution. Additionally, we would look at the different rights under the Corporations Act. The main two, which I will go into more detail shortly, are directors' duties and also the oppressive conduct regime. And then the last document which we would consider, if the person is an employee within the company, they may also have an employment contract, which might give them some rights there as well. So I mentioned the company constitution. It's a fairly basic document which sets out some basic mechanisms for running a company. It will set out how a board meeting is to be called, how a shareholders meeting is to be called, how voting rights are to be exercised. It will often set out preemptive rights for issuing shares, things like that. But the different types of disputes which I went through earlier, they're simply not provided for in the Constitution, and they don't give the shareholder that's been affected any rights to pursue any relief. So in terms of a deadlock, this is generally not covered within the Constitution. So if there is a deadlock, they won't be able to find any relief within the Constitution to move those decisions forward. In terms of declaring and paying dividends to shareholders, the company constitution will provide the power to the company to declare those dividends, but it won't set out when the company should pay those dividends. So that's completely at the discretion of the company directors. So again, there's no resolution under the company constitution. If we're dealing with an uncooperative partner, there's nothing covered within the Constitution to assist with that situation. If we're looking at oppressive majority shareholders, again, there's nothing to assist within the Constitution. All the Constitution would provide for is that decisions are to be governed by majority rule. So if you have more than 50% or often 75%, if you're trying to pass a special resolution, if you meet that threshold, then the decision can be made, and there's no rights within that document for the minority shareholders. And the final point, which I covered off on earlier, was money disputes, and where you've got money being paid to directors not in the form of a dividend. Again, the Constitution might talk about conflicts of interest and the director's obligation to avoid any such conflict. But other than that, it is very unlikely for the Constitution to talk about salaries being paid to directors or shareholders. So you can see from that table alone that simply relying on the company constitution is probably not going to get your shareholders very far in terms of protecting their rights. The next avenue which we can consider is the legislation, the Corporations Act. And there's two main sections which could potentially apply to help shareholders, being the director's duties and also the oppressive conduct regime. So director's duties, I'm sure you're all very familiar with them, and the need for individuals when they are appointed as director of a company to ensure that they're complying with their duties to the company. And so these are set out within sections 180 through to section 184 of the Corporations Act. And there's quite a few different duties which do apply. So firstly, directors have an obligation to act with care and diligence, which essentially means they need to make impartial decisions which are in the best interests of the company as a whole. They are also required to act in good faith and for a proper purpose. And then the next two sections sort of go hand in hand in that the directors have to make sure they're not misusing their position or they're not misusing the information that they've gained as a result of their position to advance their personal position. So they can't improperly use their position to make a personal gain. And if there is a breach of a director's duty, which is committed recklessly or knowingly by the director, then there are potential criminal offences which can apply under section 184. So that's all well and good. That's all binding on the directors. But how can this actually help shareholders who think that a director has breached their duties? And the answer is it's often quite difficult for shareholders to get any relief out of this division. And that's because if you don't have the company itself pursuing the director for a breach, and so often if you've got the offending director being a majority shareholder, they're not going to vote for the company to start that action. So if you've got a single shareholder or if you've got a couple of shareholders together who want to take action against the director, those individuals would need to obtain permission from the court to commence that application. and they would need to show the court that this action is in the best interests of the company and that the shareholders are acting in good faith. So they're not trying to make some personal gain, and they don't have some ulterior motive. And the other difficulty with the director's duties is that these duties are owed to the company as a whole. So the shareholder making the application would need to show that by what the director has done through their conduct or through their omissions, it has negatively impacted the company as a whole. It would not be sufficient to show that just one shareholder or a couple of shareholders have been affected. And the last drawback with going after a director for a breach of director's duties is, again, because these duties are owed to the company as a whole, if they do manage to convince the court that there has been a breach of the director's duties and that they should be entitled to damages, those damages would be paid back to the company. And so then it's a matter of how does the shareholder who's been negatively impacted actually get that money out, which would probably, again, be at the discretion of the directors. So whilst it all appears well and good to have this regime within the Corporations Act, it's fairly difficult and fairly limited in terms of any relief that the shareholders can access. The other regime, which is a bit more helpful to shareholders, is the oppressive conduct regime. And this regime says that the court can make a number of different orders. I'll go through them shortly. They can make orders if the conduct of a company's affairs or an actual or proposed act or omission by the company or a resolution or a proposed resolution is either contrary to the interests of the members as a whole, or it would be oppressive to, unfairly prejudicial to, or unfairly discriminatory against either one member or multiple members of the company. And so one of the good things about the oppressive conduct regime, which differs from the director's duties, is that you don't need to show that the conduct is oppressive to the entire company. You can get up on oppressive conduct, even if the conduct is just oppressive to one shareholder or a couple of shareholders. And another benefit of this regime is that the conduct doesn't need to have already occurred in order to obtain relief. You can apply to the court for relief under this regime if there is a proposed action or a proposed resolution which the company is seeking to make. So you don't need to be looking at conduct in the past. It can be for upcoming conduct. However, the difficulty with this regime is that even if you manage to convince the court that there has been oppressive conduct, there's no guarantee that the shareholder or the group of shareholders will get the relief that they're seeking. And that's because even though the court has a wide range of powers that they can exercise, that power is entirely discretionary. So the court could order 1, 2, 3 different types of orders to assist the shareholder, or else they may choose to do nothing. So it's completely at the discretion of the court and the judge that is hearing the matter. So these are some of the discretionary orders that the court has the power to make. They can make an order to wind up the company. They can make an order to modify or repeal the company constitution. They can make orders as to the future conduct of the company affairs. They can order the shareholders to sell some or all of their shares to another party. They can order a share buyback by the company. In addition, they can order the company to act and participate in the current proceedings. They can make an order that an appointer or a receiver or a liquidator be appointed to the company. In addition, they can make an order to restrain the conduct or the proposed conduct of a director or another shareholder or the company. And finally, they can also compel an act from another individual within the proceedings. So as you can see, there's quite a variety of different orders and quite a lot of powers that the court can exercise if it is found that there has been oppressive conduct. But again, it's completely discretionary and up to the court what they decide. And there are two main tests which are applied by the court to determine whether there has been oppressive conduct and whether any relief should be granted. So the first test, the role of the court under this regime is to terminate any oppression. So in order to fulfill that, there has to be a continuing oppression. So that just means that when the application to file proceedings in the court is commenced, that oppression must be ongoing and still affecting the shareholders claiming relief. The other test that has to be satisfied in order to demonstrate oppression is that there has to be a commercial unfairness. And this is an objective test which is applied. So it's looking from the perspective of a commercial bystander that has business knowledge and knows about the affairs of the particular company. And just a quote from the case of Campbell and Back Office Investments. In that case, it was found that there will be oppressive conduct where objectively, in the eyes of a commercial bystander, there has been unfairness, namely conduct that is so unfair that reasonable directors who consider the matter would not have thought the decision fair. So they're the two tests that have to be satisfied in order to demonstrate oppressive conduct. And then from there, it's at the discretion of the court to determine which orders, if any, should be made. And these are some examples of where the court has found there to be oppressive conduct. So the first example is where particular directors or shareholders have been excluded from participating in the management of the company. That was found to be oppressive. Another example is where shareholders were conducting a mini board meeting, if you will, before the real meeting of the shareholders. So essentially where you've got a group of shareholders who come together and are conspiring against the other shareholders to try and influence the way in which a decision will be made at the actual meeting. There may also be oppressive conduct where there is lawful termination of an employed director's contract, but it is nevertheless found to be unfair, that termination. There was also found to be oppressive conduct where excessive salaries were being paid to directors, which obviously then reduced the ability for the company to declare dividends to the shareholders. Oppressive conduct also where the company or other shareholders blocked the sale of shares to an external party. Also oppressive conduct where shareholders are denied the rights to information about the company, particularly in relation to the company's financial affairs. There was also found to be oppressive conduct where the company used its own money to defend an oppressive conduct suit. And finally, where the company moves to issue shares to an external party or to an existing shareholder to try and increase their voting power or to try and dilute the voting power of other shareholders. So all of those examples there were found to be oppressive conduct where the court may have ordered relief for the aggrieved shareholder. All right, now we'll touch base on a recent New South Wales Supreme Court case. This was heard back in 2018, and it involved an oppressive conduct application, which was commenced by Dr. Leo Shanahan. So The respondent in this case, this company was operating an eye hospital in Canberra, and there were two main groups of shareholders within the company. There was a majority group of shareholders, which held 57% of the shares on issue, and there was also a minority group of shareholders, which held the remaining 43%. And this company, not surprisingly, was doing very well, turning a good profit. And the main part of its profit came from cataract eye surgery and the revenue derived by those surgeons. Now, even though the company was doing really well, there was a dispute which arose between the two different groups of shareholders. And ultimately, this dispute arose because the minority group of shareholders, of which Dr. Shanahan was a member, they were all getting on in life and they decided to retire from practice. So they were no longer working for the company. They were no longer performing those cataract surgeries. And so the revenue of the company declined. However, the majority group of shareholders, they were all still working and they were all bringing in a lot of money for the company. And so the company continued to do well. But of course, the majority shareholders, they were getting upset because they were thinking, we're still working. We're the ones that are bringing in all of the money to the company, but we're losing 43% of our profits to these retired surgeons. And so they proposed to them that they acquire their shares. But the minority shareholders didn't want to sell. They wanted to remain shareholders of the company and they wanted to continue receiving that passive income. And so that's how the dispute arose between the two different groups of shareholders. And so once this dispute arose, the majority group of shareholders decided to commence a competing hospital. So they set up a new hospital and started running that separately in competition to the existing company. And of course, that placed a bit of financial stress on the original business. The majority group of shareholders also appointed new directors to the company. And on the face of it, it appeared that the directors were impartial, they were independent. But as time went on, it was discovered that these directors were actually either related to or their interests were aligned with the majority shareholders. So they weren't actually independent directors, and it could be argued that they weren't acting in the best interests of the company. And so because this company was now in competition with the new hospital, the way to combat that was to hire new surgeons. And there was one surgeon in particular who would have been a really good hire for the company. But these new directors, they blocked any sort of action to bring on this new surgeon as an employee of the business. And so they weren't able to put on any new surgeons, and so they weren't able to grow their revenue and their profitability because of the actions that had been taken by the majority shareholders. And finally, in 2015, these new directors decided to appoint an administrator to the company. And this was in circumstances where the company, even though it was now in competition with the new hospital, it was still doing well, it was still turning a profit. There couldn't be any sort of argument that the company was insolvent or could go insolvent in the near future. So the appointment of the administrator came as a real surprise to the minority shareholders. And so because of this conduct, Dr. Shanahan applied to the court under the oppressive conduct regime. And just before the hearing of this matter, the minority shareholders, they did cave and they did sell their shares to the majority group of shareholders. But the argument made by the minority shareholders was that they had sold their shares under value. So they didn't receive the consideration from the majority group that they thought they should have if they were sold for market value. So the relief that they were seeking from the court was compensation. They were after the difference between what they did get paid and what they think they should have been paid for selling their shares. And so throughout the proceedings, Dr. Shanahan and the minority shareholders were able to overcome those two tests and were able to convince the court that there had been oppressive conduct committed by the majority shareholders. However, the issue for Dr. Shanahan and the other minority shareholders was in relation to the calculation of the value of the shares. They were trying to include the revenue from lost opportunity in determining the market value of the shares, but the court, when they were looking at the future maintainable earnings of the company, the court found that they had actually been paid more for the shares than they should have. In other words, they got paid above market value, and so there was no compensation that the court could grant to the minority shareholders. So even though this minority group got up and was able to establish oppressive conduct, the relief that they were seeking really wasn't applicable because of the valuation of the shares. So unfortunately for Dr. Shanahan and the minority shareholders, the court ordered them to pay the legal costs of the majority group. So this ended up being a very expensive lesson and an expensive process for the minority shareholders. So that's just an example of how the oppressive conduct regime can be helpful and can provide relief to oppressed shareholders, but sometimes it doesn't work out and it doesn't provide the relief that they're seeking. So with all of that in mind, noting that there's not a great deal of rights in the Constitution and that it can be difficult to have a claim under the Corporations Act and to be able to get any relief from those claims, we'll now move on to why it's so important to have a shareholders agreement in place. And the purpose of this type of document is to regulate the conduct of the company and the management of the company, and to try and avoid any disputes between shareholders. We really want to avoid those types of situations, those types of disputes which commonly arise, and ultimately to avoid the parties having to go to court and spend a large amount of time and money litigating these issues. Another purpose of the shareholders agreement is to look at the succession planning of the company and of the shareholders. So it can stipulate in its most simple form what happens to shares on the death or total permanent disability of a shareholder, but it can also go a lot further than that in regulating the succession planning of the business. And we also can use it as a bit of a commercial divorce agreement, if you will. So we can regulate within the agreement what happens if there is a breakdown in the relationship between the shareholders and the directors. And so if we're looking at what to include within a shareholders agreement, there's 5 main areas that we really want to make sure are covered and are covered well. So the first of those is the orderly management of the company. Then we want to look at the valuation of the shares and of the company itself. We want to include some trigger events for exiting the company. Then we want to look at buy-sell agreements and the funding regime for paying for those shares. And then finally, we want to include some dispute resolution clauses. So we'll go through each of these areas in turn. So the first and most obvious section is the orderly management of the company. We want to make sure within the shareholders agreement that directors can make decisions, shareholders can make decisions to ensure that the company is moving forward in the right direction and that everyone's across what the company is doing. So we should include provisions for appointing individuals to the board of directors. So we would include a threshold of shareholding where that person can appoint someone to the board of directors. We would set out voting power and also how you replace a member of the board of directors. And then in terms of decision making, this is a really important clause to include within the agreement. Obviously, we want the directors who are involved in the management of the company to be responsible for the day-to-day decisions. But if there are any significant decisions which are likely to have a large impact on the shareholders, we want the shareholders to also be involved in approving or rejecting those proposals. So, for example, if the company is wanting to sell, if they're wanting to stop carrying on one type of business and commence a new type of business, if they're looking to take out a significant loan, or if they're trying to purchase an expensive piece of machinery. Additionally, if they're looking to restructure or to appoint an administrator, they're all the types of decisions which could have a significant impact on the shareholders and where you would want to have shareholder approval required for those decisions. You can also set out within the shareholders agreement a breakdown of which decisions need to be made by shareholders and which need to be made by directors. I've had clients before who have prepared a very detailed decision-making matrix with a long list of different types of decisions, who makes them, what's the threshold required for passing those types of decisions. So everyone's aware of what voting power they have and whose approval you need to obtain to make a particular decision. The shareholders agreement should also include provisions for declaring and paying dividends. So this might refer you to a separate dividend policy, or it might set out a certain amount or a threshold that directors have to comply with when declaring dividends to shareholders. And that way everyone has certainty as to when they can expect a dividend and when they might not expect a dividend. We also include provisions as to salaries being paid to directors and shareholders who are employed by the business. And this might simply be specifying that setting an employee's wage or setting terms of employment have to be approved by a certain percentage of the shareholders. It could be as simple as that. And then we would also include provisions as to whether the company can make loans to shareholders and vice versa. If the shareholders make loans to the company, what are the terms of those loans? Do we have interest? Is security required? All of those types of things would be included to facilitate the orderly management of the company. We might also include provisions to give the shareholders access to more financial documents relating to the company. So you might include that the shareholders are entitled to more information than they would normally have, or more regular reporting of the financial position to the shareholders. The agreement really can be tailored to whatever the shareholders are seeking and whatever they think is appropriate in the industry and the business, but these are some of the common provisions that it is appropriate to include. Then another significant part of the agreement is we need to include a provision for how we value the company and how we value the shares in the company. So if one of the shareholders is looking to sell, or if there is a trigger event, which I'll come to shortly, how do we determine what that shareholder gets paid? And this provision can be drafted in a few different ways, but we need to make sure there's some sort of methodology within the agreement. It could be a fixed amount per share, which gets reviewed annually. It could be a multiple of net profit. It could be worked out by future maintainable earnings, or alternatively, you could have it determined by an independent person, such as an accountant or a specialist valuer. And we also like to build in there a type of dispute mechanism. So if this clause is applied and the shareholder doesn't think that that's the correct value for the shares, we also have that matter referred to an independent expert who can then assess the company's situation and work out the true value of the shares, and that value would then be binding on the parties. So that's just a way of avoiding this dispute ending up in court and costing the parties a lot of money. Then we also have a section on trigger events. So this is not where a shareholder is voluntarily looking to sell their shares. It's when something happens to a particular shareholder where their shares are deemed to be offered for sale to the remaining shareholders. So an obvious example of where that would occur is where the shareholder passes away or experiences a total permanent disability event. Alternatively, you might have a trigger event if you've got a company or a trust in there as a shareholder. If they do go insolvent, or if the individual shareholder goes bankrupt, you would have a trigger event occur. If you've got a director being dismissed for a breach of director's duties, whatever it might be, or often if you've got an individual who's employed by the company and they breach their employment contract to the point where they are dismissed, that could also be a trigger event. You can also include if you do have a trust in there as a shareholder and the trust goes and changes its trustee without getting the consent of the company, that can cause a trigger event. And then finally, we've got that uncooperative partner that I mentioned earlier. If you've got a person who you just can't get a hold of and they haven't turned up to the business, you can set a time frame. If they haven't shown up in 60 days, for example, without getting the consent of the company, then they can be deemed to have offered their shares for sale. And so the point of this trigger event, it's to ensure that the company can continue operating smoothly as possible. Because, for example, if you've got that uncooperative partner and they are a majority shareholder, that's really going to hinder the company's progress. But if they do go MIA, then their shares can be offered up to the remaining shareholders, and then the control of that company remains with the existing people. You get to maintain the status quo, and then the continue can move forward past the resolutions that they need to pass and deal with the people who do want to be actively involved in the business. Similarly, with the death of a shareholder or the bankruptcy or insolvency of a shareholder, you want to have a say in terms of where those shares go. So if you have the death of a shareholder, they could leave their shares to someone under their will who's really not interested in being a part of the business and really not helpful to making any decisions. If you can override that with a shareholders agreement to say that they have to be offered up to the existing shareholders, then you get to maintain the control and the administration of the company moving forward. So you can customize this list of trigger events as much as you think is appropriate, but it's important to include them within the agreement. Then we have the tag along and drag along provisions. So slightly different in how they apply. A tag along provision is if a prospective purchaser comes along and says, I'd like to purchase your shares for this dollar amount, and let's say he makes the offer to 50% of the shareholders. If the other shareholders find out about the offer and think, that's a really good deal, I'd also like to sell my shares to that person, then they have to be given the opportunity to sell their shares on the same terms as the other shareholders. The drag along provision that's where a person comes along and they want to acquire 100% of the shares in the company. They don't want to acquire anything less. They want to be the sole shareholder. Again, you would have a threshold for the drag along provision, but if we say it's 75%, if 75% of the shareholders are in favour of the sale, then they can force the remaining 25% to go along with the deal to allow the shares to be sold to that third party. So the purpose of these clauses is to make sure that one or two shareholders don't block or don't prevent the sale of shares where it would be a really good deal for the remaining shareholders. So it gives the parties who do want to go along with the deal the ability to make sure that it can happen. And then we have buy-sell arrangements between shareholders. So where a party wants to exit and they have to offer their shares up to the existing shareholders, obviously in line with the valuation mechanism, they need to be paid for those shares. But often if you've got a company that's doing really well and the shares are valued quite highly, you might need to put in place terms as to how the shareholders pay that large amount of money to the exiting shareholder. So you would need to specify the price of the shares, the terms of payment, and also who the shares are offered to. And so we often find that rather than having a decrease in their shareholding over time, we find that it's better to have them sell their shares up front and then put in place terms as to payment. That way, the shareholder is removed from any sort of decision making, and then the company and the shareholders can work out on commercial terms how they're going to pay that shareholder for the shares that they've disposed of. And so we normally think it's appropriate to have about 30% or so of the amount paid up front to the shareholder, and then the remaining balance will often be paid back over the course of no more than 2 years. But we can also put in place mechanisms as to interest, and if any security is required to protect that payment, all of that can be negotiated between the exiting shareholder and the remaining shareholders. And we can also have a sort of adjustment if there has been a total permanent disability event and the company was paying for the insurance policy. There's a number of different provisions and adjustments that can also be built into this section. And then finally, we have the dispute resolution provisions. So as we saw from the Shanahan case, even though the minority shareholders were successful in proving oppressive conduct, they were responsible for the majority shareholders' costs. And so it turned out to be a very time-consuming and expensive process for them. And if any of you have been involved in litigation before, I'm sure you know how costly it can be. And really, whatever the parties can do to stay out of court is the best option. So we try to build into the agreement ways to keep disputes out of court, whether that be through going to mediation, or it might be appropriate to refer the matter to commercial arbitration if it is a complex matter or a complex structure. Or we often find that it's practical, particularly where you've got disputes relating to money, whether it's dividends or salaries, things like that. It's often appropriate to refer that matter to the company's accountant because they're familiar with the company, they're familiar with the personalities involved, and they would be able to, in most situations, appropriately advise on the best way to go. And so we build it in so that their decision would be binding on the parties, so the parties can't then go and appeal that decision to court and incur additional costs for the parties. But we also build it in so that if the accountant doesn't want to get involved, which sometimes they don't, they want to stay out of the drama, it can be referred to another independent expert or independent accountant to resolve the disputes between the parties. So ultimately, the point of this section is to try and resolve any issues as quickly and as cheaply as possible, and to prevent the parties from commencing litigation, unless there is some sort of urgent relief which the parties are seeking. Try to keep it out of court as much as we can. So in summary, as I mentioned, disputes unfortunately are inevitable in business and when dealing with companies. So we really need to make sure that clients are prepared for those types of disputes as much as they might not want to think about them. So putting in place a shareholders agreement, whilst it might take a bit of thinking and a bit of negotiation between the parties up front, it's a really sensible and a cost-efficient way of setting out how the company is to be run and how the shareholders' rights are to be protected, to protect against any sort of conflict in the future. Because if we don't have this document in place and something happens where the shareholders are aggrieved, as we saw before, there's very little that they can do under the Constitution or the Corporations Act. And if the dispute ends up in court, they might not get any relief at all at the discretion of the court. You've got significant legal costs and you've got the time cost as well. So if we can regulate these matters within a shareholders agreement, whether it's at the start of the company life cycle or whether the company's been running for a number of years and we're bringing in a new shareholder, for example, it really is a sensible way to go to make sure the parties have thought about these issues and documented them within the agreement. So that's all I had to present on today. Adrian, do we have any questions?
Thanks, Kate. You must have been crystal clear during the presentation because no questions during it.
Or I've put everyone to sleep.
One of the two. Let's just be crystal clear. A little bit of housekeeping. If you do have questions, fire them into the chat box, but we'll do some housekeeping in the interim. Later today, at about 6 minutes or so, you'll be receiving an email asking you to provide some feedback. There's only 5 questions, none of which are compulsory, but we do take all the feedback on board, particularly when it's we have a section there asking whether there's any particular papers you would like presented or topics. So look out for that. If you don't see it at shortly after midday, maybe check out your spam folder. We have changed our email marketing software, so depending on the sort of restrictions that you have, it may be going to spam. One question from Harry: do you have a template or questionnaire for taking instructions for the agreement, Kate?
I think we do have a dot point list of some issues, some high point issues for clients to consider, but normally the way we go about it is we put together a template document and then we would have a meeting with the shareholders and with the client to go through the key provisions and see whether they can be tailored to their particular objectives.
Yeah, what we'd normally, as you say, Kate, before that, we'd normally start with just a no cost or obligation discussion with the client just to get a feel for their business and the structure of the business and the different personalities and percentages and those sorts of things. But yeah, certainly something that we do a lot of. I would hazard a guess, doing probably 5 plus agreements like this each month for clients. Another question from Harry, which I'll answer: average cost? It depends. That's a great lawyer's answer there. This sort of work we do on a time basis because it's really open-ended as to how much work is involved and how many meetings, how many discussions. So we do it on an hourly basis, and I always quote a very wide range because of that, because you never quite know. But normally it sits at the bottom of that range, particularly where you only have a couple of shareholders. So what I'll do is I'll close off the webinar now. As I said, look out for that feedback email, and if you get the time to complete it, it would be much appreciated. Thank you for your time today, and I'm sure Kate will echo me in saying that if you're going to watch the football tonight, I hope you're cheering for the Matildas.
Go the Matildas.
Thanks, everybody.